Hi friends, this is Prem. Today we are going to discuss about the very important topic about the USCIS memo which is published on May 21, 2026. I hope you already discussed about this with your friends because this is a very important discussion within the Indian community. All because of the following text. It states that an alien who is in the US temporarily and wants a green card must return to their home country to apply, except in extraordinary circumstances. So, lot of question arises. What are the extraordinary circumstances? Do I need to go to India for getting the green card? So there is no more I-485 can initiate inside the USA. So lot of questions are starting within the community. Today we are going to discuss all our questions with our attorney Henry. He is from Manifest Law Firm, and Manifest Law Firm is given a free consultation for your visa queries and any green card queries. Just scan the QR code on your screen and schedule your free consultation. Before going to the video, please take a moment and just give a hype using the hype button on your YouTube app. So it will reach more people, so awareness can spread among the Indian community. Let's go back to the video. Hi Henry, thanks for your time. I know it's very important video. You might have discussed so many times about this USCIS policy memo with your colleagues. Before going to this video, வணக்கம், எப்படி இருக்கீங்க?
வணக்கம் பிரேம், நல்லா இருக்கீங்க?
Yeah, I'm good, Henry. Can you please give me the overview? What is this memo?
The first thing is that this is a memo that is intended for the USCIS officer to give them kind of guidance or instruction on how to make decisions on adjustment of status applications. The second thing that is important to know is that it is only impacting adjustment of status, which means the process of applying for a green card inside the United States. It is not impacting any change of status to another temporary status. So if you're applying for B, F, H1B, L, none of those things are impacted. If you apply for OPT, this memo has nothing to do with your case. So, because a lot of people have been asking me, does it impact somebody going from F1 to H1B? No, this memo is specifically about the USCIS process to adjust status. And it doesn't really create any new rule or regulation. It's just reminding the officers that they already have the power or the authority to say yes or no, because adjustment of status is not something that is a guaranteed option for people.
Sure, because why everyone is panicking because of the line they said like an alien who is in the US temporarily and want the green card, they must go to their home country and apply, except extreme circumstances. So does it means there is no more I-485 can apply under employment-based green card inside the USA?
No, the law didn't change. The law still says that people can apply. It's not like USCIS is going to stop accepting I-485 applications in the mailroom. They're not going to start sending the forms back and saying you can't apply. I do think there is going to be more denials. But the USCIS officer basically is doing a balancing equation of why should you apply or why you should not apply inside the United States. They're kind of saying that most people should go to do the consular processing because it was always intended that way, and that adjustment of status should be an exception. But I do think that having a job, having a sponsor, applying for AOS based on, let's say, I-140, that's, from a big employer in the United States, those are all things that you can use as positive factors of why you should be allowed to AOS. Now, people have to include more documents and more details in the AOS case than what they previously did. So I would recommend a lot of people talk to an attorney before you file to make sure that you understand if your case has any, I would say, risk factors or red flags.
Okay, so does it impact any I-485 is already been submitted and those people are in EAD and advance parole?
Yes, because it's not a new rule or a new regulation, then this is just guidelines to the officers, and it will be impacting every decision they make now, even if the case was already filed before this memo came out.
Okay, so if anyone is in advance parole, they went to the India, they are planning to the travel, does it impact their travel? So because what I'm asking, right, if they are entering to the USA, whether the immigration officers can ask, so I won't allow you to enter on the advanced parole, just go and get visa stamped or get the green card approved.
I guess maybe it would be possible, but I mean, the memo doesn't say anything about the advanced parole. Um, Generally speaking, I would recommend people to not use advanced parole unless they really have to. If you're already somewhere and you have AP, then there's nothing more you can do about it. But just because you have AP doesn't mean that the officer at the airport is obligated to let you in. They always have authority to say no. And that's why for a long time now, I have been telling people, even if you get AP, don't use it unless it's for a very important purpose, right? Like it's much safer for you to just be inside the US and wait for the green card and then travel after you have a green card. But I don't think that it's going to have an impact on people getting rejected at the border more than before.
Okay, got it. So as per the AC 21 Act, the people can do the I-485J when they are trying to switch the employer after they file the I-485. Does it impact the I-485 supplement as well?
No, it doesn't change anything in the rules for porting from one employer to a different employer. Just the approval or denial of the 485 itself is a discretionary, meaning that the officer, USCIS officer, does not have to say yes. They can say yes or they can say no. That is their decision. That's basically what the law says. If you are on an H-1B, I think you are very low risk because, and again, like if you have a different employer filing the 485J, it's a good sign that somebody wants to hire you, right? But it will depend on the specifics there. For example, if somebody had an H-1B, now they have a pending 485, but they didn't extend their H-1B, I think that would be a bad thing. Like, I think that's a negative factor. So even if you already have a pending 485, if you change employers, I would really recommend, if possible, that the employer still file the H-1B transfer to make sure that you keep the H-1B active all the way until you have the green card.
Yeah, those are the great recommendations. Thanks, Henry. So can you please tell me what are all the employment based categories getting affected? Say example, we have the EB1 and EB2 NAW, EB2 regular, EB3, EB4, EB5. Does it impact all the categories?
Yes, because all of those categories and all of the family-based categories, like spouses of citizens, green card holders, children, all of those categories rely on the same section of the law, which is Immigration and Nationality Act 245A, for getting the green card, right? So the section that is not impacted are people like under the VAWA, Violence Against Women Act. There's a separate section of the law for their adjustment. Or people who are filing as asylees and adjusting status, that is a separate section under the law. But almost everybody else falls under the 245A, and that is impacted. So it's just that different people are going to have different positive versus negative factors in their case. It's kind of difficult to explain, but I can give some examples of sort of who I think is a higher risk and who I think is a lower risk.
Got it. So can I say, like, if someone in H1B or L1 or F1 visa, if they are trying to apply the green card under the any employment based category, can comes under the low risk, whereas the B1 B2 tourist visa, if they are coming and if they are trying to apply for the green card, so they will be the higher risk. Is my understanding correct?
Yes, absolutely. So I would say the highest risk are going to be people who are entering on a B visa or some kind of a parole, and then they apply for AOS, and the underlying status that they had expires long before they ever get an interview or get adjustment decision on the adjustment of status case. Whereas if you are on an F1 and or especially on an H1B or L1, which are called dual intent visas, then that is going to be lower risk. But in addition to that, just the status that you are using, there's going to be other factors that the officers are considering. So, for example, I think if you have an EB2 NIW approval, and that is why you are adjusting status, that you're going to be very, very having positive factors, because if USCIS already determined that your work is something that is in the national interest, right, that is very important and valuable for the United States, then that means that they have a much stronger interest in allowing you to adjust status. Whereas somebody who doesn't have a job, doesn't have a family, and is not maybe active in their community at all, then they're going to be less likely to approve the case.
Yeah, makes sense, Henry. So for the worst situation, if anyone's I-485 got denied and they don't have that visa, say example they are in the EAD and advanced parole, so what is their lawful status here then?
If your I-94 has already expired and then you get a denial on the 485, you are going to be out of legal status, and the denial notice will probably say to you that warning, you are going to be unlawful, meaning that you are, once they start counting the days of unlawful presence, they call it, then you are in trouble, because if you have too many days of unlawful presence, it becomes very difficult to do anything inside the US. And if you leave the US, you can be banned from coming back in. So if you don't have any underlying status and you get denied for the 485, either leave the country or talk to an attorney quickly, because you need to very fast decide what is going to be the next step in your case.
So is there any possibility to apply the appeal if any deny comes under the I-485?
It is possible to ask them to reopen the case and change their decision, but because the adjustment of status is what they call discretionary, meaning that the government doesn't have to say yes, there is limits to what you can do. You can ask USCIS, please reopen the case and look at it again, but if they say no, there's not that much you can do. It's not like with an EB1A where you can sue the government and say, like, I think I deserve the EB1A, and then the court says yes. Right? The court in this situation would say, hey, we can't get involved. It's up to USCIS to decide who gets to adjust and who doesn't.
So when they ask about the consular processing, it is like getting an appointment from India. Say example, if their home country is India, so go to India and get the appointment and just get it stamped and come with the green card. That is the meaning, right?
Right. So to get a green card, basically, two steps that somebody has to complete. The first step is an immigrant petition. So that could be the I-130 for family cases, or I-140 for, EB-1, 2, 3, 4. The number one thing is the petition. And then the second step is to actually get the green card. And then if somebody is inside the United States, they can file for the adjustment of status. If somebody is outside of the US, then it's called consular processing, and it involves submitting an application to the embassy or consulate, sending some documents with it, then getting an interview scheduled, and then going to the interview. And after an interview, a person would get what's called an immigrant visa. It's a special visa that's valid for 6 months. And if you use that visa to enter the United States, then the moment you come in, you become a permanent resident. And then they send you the green card in the mail afterwards. The problem with the consular processing for green cards is that it usually takes much longer than visa interview for a temporary visa. So Indians are already waiting a long time for their H1s or their F1 interviews. If the embassy or consulate is very busy, this new policy of pushing more people to do consular processing could just increase the wait times even more, because it's even more difficult to get an expedited appointment for an immigrant visa than it is for somebody with an H1B.
True. Yeah, the interview is really scary things, and I don't think it's an option for Indians at this point of time. And I have one more question. I believe it's the last question. So when you say the I-485, they can deny because they have the discretion power now. At what point of time they can deny? Whenever I just submit the I-485, whether that time they can deny, or if I get the EAD and advance parole, there is a point of getting the green card at any point, whether they deny my application.
Well, the process is going to be the same that it is now. It is very unlikely that somebody would get denial before they even do biometrics or get the EAD or things like that. Then the memo specifically says, remember, officers, you do have the discretion to say no But if you do say no, you have to issue a decision and you have to explain why are you saying no. So just like when you are applying for any other case, usually the decision comes in the form of either approval notice, which is a short thing that just says, "Yeah, you're approved," or if it is a denial, then it's going to be several pages of explanation of what is the law and why are they saying no to your application, why are you not eligible. So the memo says if you are going to say no to the 485, you have to write down what are the negative factors that you are relying on for your decision.
Great, Henry. Yeah, thank you so much because you clearly explained this is not something new, it's already there, but they given the more discretion power, or they given the more explanation to the officers. So it is not stopping anyone to apply the I-485 inside the USA, right? So they can do whatever they are doing today.
Correct. So people can still submit the cases. I would just recommend that if you are not sure if you are high risk or low risk, then talk to an attorney. And if you already even have a case pending, and you are like, oh, I didn't I don't know how this affects me. Schedule a consultation. Contact us at Manifest, or if you already have an attorney, reach out to the attorney who is on your case to basically explain to you how does this impact my case. Am I in a high risk category? What other documents or evidence would help my case? Because even if your case is already filed, you can bring new documents to your interview if an interview gets scheduled. So you should be prepared. And also, I would recommend, if possible, have an attorney with you at the interview. That would protect you because sometimes USCIS officers are more strict when there's nobody else helping you. But if there's an attorney at the interview, it usually keeps the officer more under control, and they are not gonna be so strict or ask questions that they shouldn't be asking.
Wow, that's a great advice, Henry. And yeah, that is definitely, yeah, they should do at this point of time. And you are given the other good advice. So just keep the H1B visa or whatever the visa you are holding until you get the green card. Because some people, they remove the visa category just like once they get the EAD and advanced parole, they are switching from visa category to the EAD and advanced parole. But at this point of time, it is very risky one because of the policy memo. Yeah, that is a great advice, Henry. And I promise this is the last question. Is there any possibility to go for a challenge in the court?
I mean, I think that there will be some challenges, but I'm not sure how those are going to work out. I mean, the law does say that the officer has discretion. So unless they can point to something, illegal happening, like in the back room that they are saying, say no to everybody or something like that, then I think it's going to be very difficult. But I'm sure there's going to be some challenges, and we will see what happens next.
Thank you so much, Henry, because when this memo released, there are so much confusion among the community. Now we got a clear picture because of you. Thank you so much, Henry, again for your time. Nandri.
Nandri.